When your child turns 18, the law considers them ready to manage an inheritance, even if you know they are nowhere close. And without the right plan, anything you leave behind can land directly in their hands. At that age, a bad friend, one lawsuit, or one impulsive decision can wipe out everything you worked your entire life to build. I'm Talai, a trust and asset protection attorney, and I help California families structure their inheritance plan so that wealth is passed down responsibly without putting kids in position they're not ready for. This video walks you through simple, legally sound tools to protect your children's inheritance from themselves so your legacy isn't spent on a sport car at age 19. Nothing wrong with a sport car. Maybe at age 19, that would be the question mark. Let's get into what really happens when you leave a large inheritance outright to your kids in California. You've built your wealth over decades. I'm sure there's got to be some, let's say, real estate, maybe investment accounts, maybe a business. And naturally, you want your children to benefit from it. The assumption that young adult can responsibly handle sudden influx of money is one of the most dangerous mistakes I see. I have watched inheritance evaporate because a child made one poor investment, fell into the wrong relationship, or simply didn't have the maturity to manage a substantial sum. Even adults in their 30s or 40s can struggle if they have never handled meaningful wealth before. And in California, if your plan leaves assets to your children outright, whether through a will, through intestacy because there was no will, or even through a trust that requires outright distributions, they receive that money with no guardrails, no buffer, and no protection the moment the state or the trust administration is completed. One client left her son $400,000. The son was just 23 years old, and 2 years later, the entire inheritance was gone, spent on a car, a risky business deal with a girlfriend, and paying off his girlfriend's credit card debt. Sadly, this type of story is not rare. It's common, and often the parent's intention to help their child ends up doing the opposite. All right, so let's talk about the alternative. How do you protect your children from the risk that comes with sudden wealth? In California, the living trust is the cornerstone of responsible inheritance planning. Without one, your assets go through probate, a public court-supervised process, and the outcome depends entirely on your child's age. If your child is under 18, the court cannot give them the inheritance directly, which means a guardianship or a blocked account may need to be set up, creating more delays, more cost, and more oversight. And once the child turns 18, the court hands everything over to them outright. For most 18-year-olds, suddenly receiving full control of substantial inheritance is a recipe for disaster. A comprehensive living trust allows you to decide how your children benefit from the inheritance and when. But here's where I differ from many other estate planning attorneys. I do not believe in giving your kids lump sum distribution when they turn 25, 30, 35, or any other magic age. Life doesn't care what age your kids are when something goes wrong. If your child is 30 and in the middle of a divorce case or a lawsuit, the last thing he or she would want is to be distributed a lump sum money from your trust. Instead of trying to predict the right age for a lump sum payout, I take a much more protective and flexible approach. I use an inheritance trust. With an inheritance trust, you're not giving your kids a big check at a certain age. Instead, you're setting up a structure built right into your trust that springs into action only after you pass away. This trust does not require or force any lump sum distributions. Instead, the trust provides for your child's health, education, maintenance, or support while keeping the inheritance safely protected. This means your child never receives money at a bad time. If they're going through a lawsuit, the trust protects the assets. If they're divorcing, their spouse cannot reach the inheritance. And the trust also prevents a spouse from ever being added as a co-trustee or gaining access to the assets of the trust. Even if your child were to pass away, the inheritance does not shift to their spouse. It stays in your family bloodline. The assets stay in the family by passing to your grandchildren, and if there are no grandchildren, to your other children. The inheritance trust supports your child during their lifetime, but it never becomes marital property and it never leaves the family. Parents often ask, when does my child get control? This is the beauty of this system. You can choose an age, maybe 25, maybe 30, when your child becomes the trustee of their own trust. But becoming the trustee is very different from receiving a lump sum payout. They now manage their trust, but the inheritance stays inside of the inheritance trust, protected, insulated, and safe from outside threats. Imagine you pass away and your daughter is 19. The inheritance trust that was built inside of your revocable trust or your any other trust that we have done for you becomes active, and your hand-picked trustee, successor trustee, steps in. They use trust funds for your daughter's education, living expenses, medical needs, whatever she truly needs. She benefits from the trust without having direct control of the trust. When your daughter reaches the age you chose, she steps in as the trustee of her inheritance trust. She now manages her own inheritance trust. She makes investments decisions. She decides how the money is used for her health, education, and maintenance and support, but she never receives a mandatory lump sum distribution, and the assets stay in the protective wrapper throughout her lifetime. She has control, but not exposure. She has flexibility, but not vulnerability. This is what responsible inheritance planning looks like. Now, some parents hear that inheritance trusts become irrevocable after they pass away, and they worry about higher income taxes. And that concern makes sense. If these trusts aren't drafted correctly, they can get hit with less favorable tax treatment. What most people don't realize is that a lot of attorneys try to avoid dealing with the issue by using old staggered distributions, provisions like that in the trust. It is not because that's the best plan for your kids. It's usually because the attorney doesn't feel comfortable handling the tax rules that comes along with keeping assets inside of an inheritance trust, inside of an irrevocable trust. As someone who practices both estate planning and also tax law, I take a different approach. I draft these inheritance trusts in a way that keeps all the legal protections in place without creating a tax problem for your kids. So your child gets the benefit of a long-term asset protection and does not get penalized at tax time. Another essential tool in California is the Spendthrift clause. This simple provision does a lot of heavy lifting. It blocks creditors, ex-spouses, and anyone trying to take advantage of your child from reaching into the trust and grabbing what you set aside for them. And when your plan, your estate plan, uses an inheritance trust for your child where you're not forcing lump sum payout, that protection becomes even stronger because the assets stay inside the trust instead of landing in your child's personal bank account. I've seen this play out in real life many times. A child going through a divorce, a lawsuit, or even being pressured by someone with bad intentions, yet the assets remain completely untouched. A spendthrift clause, when paired with a well-drafted inheritance trust, create a level of protection your child simply cannot get if they receive the inheritance outright. It is one of the most effective shields you can give your family. Special considerations for blended families. If you have a blended families and you're thinking about putting your trust has to be drafted properly. Blended families require extra clarity because California law does not automatically include stepchildren, and families often have different expectations about who should receive what asset from the trust. But the most important part of a planning for blended family is not just dividing inheritance. It is structuring the trust so everyone understands what happens when the first spouse passes away. This is where many trusts go wrong. If the trust isn't drafted carefully, the surviving spouse can end up with total control over all the assets. And even if the spouse has the best intention, life happens, relationships change, and new influences enter the picture, and sometimes children from the first marriage are unintentionally or intentionally cut out. It's one of the most heartbreaking situations, unfortunately, I see. A properly drafted trust prevents that. It clearly explains what portion of the estate becomes locked in for the children of the first spouse to pass away and what portion remains available for the surviving spouse's need. But the surviving spouse cannot later redirect asset away from children you intended to protect. Inheritance trusts become incredibly valuable here because they allow you to set aside your children's share in a protected structure that cannot be changed after you're gone. This is especially important when stepchildren are involved. If you want them included, you have to say so explicitly. If you want each side's biological children to inherit from their own parents' share, the trust has to spell that out. And if you want your estate to ultimately stay within your family bloodline, the trust needs to direct exactly where the asset need to go after each spouse passes away. If you take nothing else from this video, let it be this. You do not have to trust that your child will figure it out at age 25 or 30. You can create an inheritance trust that protects them at every stage of life, avoids forced distributions, shields their inheritance from divorce and lawsuits, and gives them control when they're ready, not when the calendar hits a certain year. And if you want to take the next step in protecting everything you've built, I strongly recommend you watch my next video, Charging Order Protection in California, Why Your LLC States Matter. This single concept can mean the difference between keeping your investment safe or losing them to a creditor. I look forward to seeing you over there.